Let's see. Let's see if that's any better and where we're at now. We may have solved the problem, I hope. As always, in addition, friends, feel free to ask your questions online through our social media, or you can respond through call inquiries. Shoot us an email, whatever you want to do. The phone number to call in, 347-7238. We'll take your calls live on the air. Friends, today we're going to jump into and we're going to talk about what you definitely don't want to do before you file a bankruptcy in anticipation of the bankruptcy. And now with all these things, obviously, we're making blanket statements. I don't know your circumstances. There may be some things that are different in your case-by-case basis. And of course, you can get qualified, competent counsel to assist you and guide you through that process. But it's ultimately a question of, what makes sense. So these are broad advice, these are blanket rules, but definitely if you are questioning something, talk to a lawyer. So, number one, this is an easy catch-all. Do all the things that we talked about in a prior episode. So don't hide anything from your lawyer. Don't, not take advantage of attorney-client privilege. Be timely. Don't fail to show up. So first easy one is go back, if you haven't seen our episode that talks about things lawyers wish you knew. Do all those things and don't not do them. So that's the easy one. Now let's talk specifically to bankruptcy. You don't want to deplete your exempt property. And what do I mean by that? Well, in Chapter 7, in exchange for the fact that you get to wipe out some of your debts, you are limited to the things you get to keep. There's things you get to shield, and if there's no law that protects it, then you're at risk of losing it. And we talked about that in prior episodes when we talked about bankruptcy. Well, so if you have to sell your assets, sell your property, and do certain things, we don't want to get up or have to sell something that we could keep in the bankruptcy while retaining something we couldn't keep. So let's give an example. You have 3 cars. You're a married couple. You only get 2 motor vehicle exemptions. In addition, you have a 401k that's completely protected under Oklahoma law as a qualified retirement fund. You're in a hard spot. You need some money. Understandable. Should you, 1, sell one of the 3 cars, or 2, pull money out of your 401k? You don't want to pull money out of the 401k. It's exempt. It's protected. You're not going to lose that in the bankruptcy. But the 3rd car, you would. It's going to be gone, and you're still going to end up having to have that money go to the other creditors. So it makes more sense to deplete, to sell a non-exempt asset as opposed to an exempt asset, something that's protected. So that's the first thing we're going to talk about. The second thing that we're going to talk about today is what are known as preferential or fraudulent transfers. And what those are is bankruptcy courts have look-back powers. We can undo transactions in time if we tried to do things to game or cheat the system. Now, understandably, that most people that we know and we meet, our clients aren't trying to do something wrong. They don't want to cheat the system. However, they may inadvertently still trip up and do something that is not permissible, that causes a problem. So what might those things be? Specifically, repaying family or friends before you file your bankruptcy. So where this comes up the most often is tax season. You file a tax return, you get a very large refund. Now that refund before you file bankruptcy may be non-exempt, or if a portion of it is earned income taxes, federal EIC, that's protected, that's exempt. So that EIC you could go into the bankruptcy with, you wouldn't even lose that. Unfortunately, though, if you owe friends or family, they're just a regular unsecured creditor in the eyes of the law. Now, they may be special to you, but not to the bankruptcy code. You decide, well, I'm going to take $5,000 of my tax refund, I'm going to repay my brother, and I'm going to file bankruptcy. The problem is that that $5,000 went to one person when it could have been distributed based on what the law provides, more evenly or fair to all the creditors. So, first, you could have kept that money as being exempt, if it was EIC, and then you could have used it after the bankruptcy and had no problems. But because you transferred it before the bankruptcy to one person preferentially, the trustee is now going to require that money be given back. And if they don't, you either have to repay it or they're going to sue your family or friend to take it all back. So really, what we should be saying is don't make preferential or fraudulent transfers, but where this comes into play the most often means be very, very trepidatious about trying to repay your family or friends. And I know they've taken care of you when hard times were tough. They've been the ones that have helped you out. They've loaned you money, or maybe they gifted it, and now you're in a situation where you can pay them back. However we want to call it, whether it's a gift that you regave, whether it's a loan that you repaid, the fact is you can't make them whole and then also say, well, I don't like the credit card company and I don't want to pay back my $30,000 in credit card debt. You've got to be very careful about those kinds of things. Can it be done? Maybe. You got to talk to a good lawyer before you try to do those things. Another thing we don't want to do, not file taxes. I hear all the time various reasons and excuses for not filing taxes. The only reason you shouldn't file taxes is if you're not legally required to file taxes, meaning that your income is below the reporting threshold set by the IRS for that particular calendar year. Changes every year. They publish different tables. Let's just call it roughly about $12,000. So if you have income below $12,000, then you don't have to file that tax return for that year. But otherwise, if you do have to file a return, there's zero excuse for not filing a return. And I want to break down some of those excuses. Excuse one, I filed for an extension. Well, why did we file for an extension? If the reason you filed for an extension is that you just simply could not get the return prepared, that it's complex, it's lengthy, and you need more time, it's a legitimate excuse for certain people's, but most of the time it's not applicable to the majority of my clients. The majority of our clients, and probably our listeners to this, if you're just single W-2 wages, that's a basic tax return. You could have it prepared. There's no need for an extension. Now, if you're self-employed, you own a company, you've got Schedule Cs, you've got other complex things, you've got to have an accountant prepare those and they're busy, maybe. But overall, truth be told, I own a small business. I have a complex tax return, and I never file for an extension. I still get them done on time. So do your taxes on time. But here's the bigger reason why people don't file their taxes timely, or they file an extension, and that's because they owe. You think that, well, I owe the government money. I've got to pay taxes. So I just won't file a tax return, or I'll file an extension, both of which are terrible, terrible ideas. Number one, the extension extends time to filing the return. It doesn't change when the tax was due and owing. It's still due on April the 15th. So even if you end up paying your taxes on October the 15th at the end of that extension, it's true that there's no penalty for late filing the return, but you're still going to be charged interest and penalties all the way back to April the 15th for 6 months on the actual tax debt. So you didn't actually help yourself by extending it. You might as well just have filed the return on the 15th of April when you knew you owed the taxes, and you set up a payment plan or some other arrangement to deal with the taxes. Same deal as I just mentioned. If you don't file the return at all, don't even ask for an extension, now you're dealing with interest and penalties for non-filing the return and for the tax debt you owe. So those are problems. But here's why in the scope of bankruptcy, it's a really bad idea to not file your taxes. Number one, you've got to do it to file bankruptcy. It's a requirement of the bankruptcy code that you've been compliant with the tax law for the last 2 years. You've got to turn over to the trustee those tax returns. In other words, you are going to be told by your lawyer, I need tax returns. If you haven't filed them, you're going to have to go file them now anyways. You might as well have done it timely. And if you haven't filed the return, there's no chance we can wipe that tax debt out in a Chapter 7 bankruptcy. There's many tests, and it's complicated to whether or not you can discharge income taxes as part of a bankruptcy. But one of them, the only thing we're going to touch on right now here today, is the return has to have been filed at least 2 years prior to the date of petition. So you tell me you owe income tax debt? First question, when did you file the return? You didn't? Well, they're not going to get wiped out. End of conversation. If you filed the return and they didn't collect on it, and it's now over 3 years old, we might be able to discharge that tax debt as a part of your bankruptcy if you had filed the return. But if you never bothered to file the return, or you just got around to it a couple weeks ago, it's going to survive your case. It's non-dischargeable, so that wasn't such a great plan. Now, this is another big one that comes up, and obviously that is, don't incur new debt. You're about to file bankruptcy. The goal is to get out of debt. There's a whole lot of rules, but we need to be very, very careful, and you should talk to a lawyer before you start to incur additional debt after you've thought about bankruptcy, or definitely after you've met with an attorney and retained them to file bankruptcy. It can cause problems for a lot of reasons, one of which, though, ultimately is bad faith. That if you knew you were not going to repay that bills, you never had any intention of repaying your creditor, you might lose your discharge either in whole or in part. And that's not what you want. And it's definitely not something that you could do at the last minute when you were already so close to possibly getting a fresh financial start. So we don't want to incur debt. We don't want to do anything additional. You can't borrow money to pay your attorneys. You can't use a credit card to pay your attorneys. You can't go run up those credit cards at the last minute before you file a bankruptcy. You don't get a bunch of free stuff thinking, well, now I don't have to repay that. I'm going to wipe that out. That could bite you in multiple ways. It could just be that you end up having to pay those debts. It could be that you end up having to pay all your debts and you lose your discharge altogether. But I want to give a big caveat to this. There's a difference between incurring new debt and simply not paying down old debt. What I mean is, if you've been making minimum payments or any type of payments on things that you would wipe out in your bankruptcy, medical bills, credit cards. Now we're not talking about student loans or alimony or child support. I'm not talking about a car you want to keep or a house you want to keep, but the things you want to get rid of as part of your case. If you've been making payments on those, oftentimes it is recommended you stop making all those payments. As I said, I cannot encourage you by law to incur any debt in anticipation of bankruptcy, cannot recommend you go borrow more money. But that does not mean you have to decrease your debt or pay it down any further if you've already resigned yourself to filing a bankruptcy. That's just status quo. We're just leaving it where it is. So what I always tell people when they're asking about, hey, should I keep making payments on the cards, is definitely keep doing whatever you're doing until you've made a decision. If you haven't resigned yourself to bankruptcy, if you haven't hired an attorney, it's dangerous to say don't pay anything, because doing so could put you down a path that you may not have been fully committed to. If we say stop paying the credit cards altogether, and you decide I wasn't going to file bankruptcy, well, now they may all be suing you, and now you have no choice, and you are going to be filing a bankruptcy. So we don't want to rock the boat and change status quo until we've made up our mind. But once we have made up our mind, if we've concluded, without a question, you're going to file bankruptcy, either you can do it on your own or you have an attorney lined up and you're going to hire them, then I definitely recommend stop making payments on all of those cards or medical bills or whatever it is that we're going to discharge, because there's no need to be doing further activity on those. Okay. Some more things that we need to be aware of as far as the don'ts. This one's tricky because life doesn't always permit us to control it, but overall, don't move. Why? Well, two concerns. One is jurisdiction, and second is exemptions. Where you have the ability to file a bankruptcy is based on where you have resided as far as federal districts the majority of the prior 180 days before filing. In other words, if you've been one place 91 days or more out of the last 180, that's the place you're going to file your bankruptcy case. If you live in the Western District of Oklahoma, like Oklahoma City, and you move to Tulsa, the day you move, you've still got 90 more days in which you could file in Oklahoma City. Or if you look at it the other way around, in which you have to file in Oklahoma City and you don't get to file in your new location. After the 91 days, now you have to file in your new location, and we have no choice to file in the old location. So if you've got a lawyer you've been working with them and you move, you've got a limited time window to use them, and after that you've got to use somebody else or do something different. Or maybe you want to do something different and you can't do it just yet. We talked about something simple like Oklahoma City to Tulsa, but if you move from Oklahoma City to Anchorage, Alaska, and you'd like to file a bankruptcy up there quickly, you cannot do that because the correct jurisdiction is still Oklahoma until you've been in the new location the majority of the 180 days. But then, even more complicated than where you can file the case is what exemptions are applicable. And so, just like we were talking about when I talked about don't deplete exempt property, and we've talked in prior episodes about this idea of shielded property, exempt property. The bankruptcy code, bankruptcy law, is federal. And so the federal law is, a starting place, and it does have exemptions. However, it also has an opt-out provision for those exemptions to allow the states to use their own state law exemptions. Some states opt out, some don't. Everyone's a little bit different. The majority, though, have opted out, including Oklahoma. But as far as whose rules are applicable, it's determinative of, first, have you been in the same place for the last 2 years? If yes, then that state law applies. If not, we're going to look where you have spent the majority of the 180 days preceding the 2 years preceding the filing of the case. So look when you're going to file bankruptcy, back it up 2 years, then look at the 180 days before that period. Where did you live the majority of that time period? 91 days or more in that time frame. The problem, obviously, is that is designed to be a long time ago, so we can't game and cheat the system. Let's say that there's a state that's very generous in their rules and their exemptions. Let's just say it's Oklahoma. Well, if you live in another state and you decide, I want to file bankruptcy, so I'm going to move to Oklahoma and I'm going to file bankruptcy, you would need to live here for 2 years before you can use Oklahoma exemptions to be able to do that, so that you cannot just try to pull a fast one and use a different state law easily. Point being, though, is you're pretty much bound to where you were for a while. So I say you need to be mindful of moving if you already are having very difficult or dire financial situation, because you may end up messing up the jurisdiction where the case is filed, or you also may end up using or not using exemptions that you thought were available or more favorable without realizing it. You move to another state, time goes by, it's 2 years, you didn't even think about it, now you want to file that bankruptcy you meant to file before. Oh, lo and behold, their exemptions are way worse than you were when you should have done the case 2 years ago. So those are things you need to very much take into consideration. So we talked about, if you can, don't move. Now, this last one, it is similar to what I talked about when I said don't repay friends or family, and that's don't transfer or give away property. It's somewhat surprising to me how often people think they've got a good, clever idea, and that's something that me and the government and the millions of other lawyers that practice law hadn't already thought of beforehand. Folks, reality is, if you've got a cool, clever idea, it's not a new idea. Someone's already thought of it, and there's probably a rule to stop you from doing it. So, we talked about exempt property. You have a boat and 3 cars, and you're married. The boat's not protected. One of the 3 cars is not protected. Well, so, I'm just going to give it to my brother, and that way he can have it, and I'm going to file bankruptcy, and it won't be a problem. It'll technically be my brother's boat, but he'll let me use it, and I'll still have control of it. It's just his name. Yeah, no, that's a fraudulent transfer. A couple things is going to happen. One, you're going to disclose it like you should in the bankruptcy, and now the trustee is going to claw that back, take it, sell it, and administer it just like they would have anyways, even if you'd had it and disclosed it. Or it's going to bring up even bigger problems because of the fact that we made that transfer. Or alternatively, you don't disclose it, you've committed criminal fraud, you may get prosecuted, and you very likely will lose any possible bankruptcy discharge because you didn't disclose things in the case correctly. So there is what is known as exemption planning. There are ways with competent, experienced counsel to move things around and do things that can help you shield and protect your assets before bankruptcy. But these are definitely not things that I recommend be undertaken without a lawyer or even with a lawyer who doesn't specialize in bankruptcy law. Because what'll end up happening is that you may inadvertently do things that backfire greatly on you or your friends or your family. Don't repay large sums of money. Don't transfer property. Don't gift things. And the same goes for even where you think you're being a beneficial, good person as a recipient. So you've got a family or friend, and they decide that for maybe estate planning purposes or safety, they're going to put your name on some of their property. We discussed this a little bit in some of the pitfalls in our episode where we talked about estate planning. So you have an elderly parent, and your elderly parent has a home. They want to try to avoid probate. They can't afford a trust, or they don't want to do a trust. They don't want it to go in a will. So they just do a quitclaim deed. Now that house is owned in joint tenancy between your parent and you, but you file a bankruptcy. That house is now part of the bankruptcy, and if it's not your homestead and you're not residing in it, it's non-exempt property, and that house very likely could be at risk of being taken and sold as part of that case. So you need to be careful, and other people need to be careful. What is yours? What comes into your estate? Where these lines start and stop on some of these assets. So let's go back. Let's summarize a few of these things because we've touched on a couple of the don'ts. The don'ts. Well, number one we mentioned, don't hide anything from your lawyer. Watch the entire episode or re-listen the episode where we talked about things your lawyer wants you to know. Don't hide anything. Don't be late to court. Be punctual. Those are the broad rules for every case, basically. But now to the bankruptcy, the things we talked about for don'ts. Don't deplete exempt property. Don't repay family or friends. Be very careful about preferential and fraudulent transfers. Always file your taxes on time, or if we're phrasing these as don'ts, don't not file your taxes, and don't ask for an extension if the only reason is you're going to owe and you've already got everything worked up. If you've got the tax return worked up, you know what you're going to owe, and you're just filing the extension because you don't want to file the return, don't do that. There's no reason. It's silly. File the return, set up a payment plan, get things worked out. Don't just try to kick the can down the road for no reason, because again, the date of the return filing is going to be very important for future ability to wipe out taxes by the time you meet with a bankruptcy lawyer. Don't incur new debt. But, like we talked about, you also can tentatively don't keep paying on things that you don't have to. Don't pay credit cards, medical bills, payday loans, unsecured debt that's going to be discharged as part of your case because, as I said, you can't incur new debt. Law says you can't go out and borrow money that you plan to wipe out, but you also don't have to pay it down anymore from the point, if you've already borrowed it previously in good faith. Don't transfer or give away any property because there's no real gamesmanship to this. The law is designed to look back in time to undo those things. You don't get to decide, well, I've got all this stuff. I think I'm at risk at losing it, so I'm just going to move it around and be real cute and creative. I've heard it. It'll backfire. Trust me, the law and the government has thought of these things long before you thought it was a good idea. And then, if you can avoid it, and I understand life rarely lets us control all of these things, but to the extent you can, be careful about moving between federal jurisdictions. Don't move out of the district if you already think you're going to file a bankruptcy, at least especially without talking to a lawyer and having a plan, because it could change where you have to file the case. It could also change over time what state exemptions are available or applicable. So hopefully everyone was able to hear the episode. I know we had some technical issues and we had some echo going on earlier on. I'm not sure if that was all resolved or not, but I think from our end it was sorted out. We we apologize again for last week there being a gap in our airings and we had a rerun. However, again, I think I've got about the world's very best excuse, being very excited for my beautiful baby girl daughter, Emery Joy Sansone. Friends, we're going to be back next week and continuing to roll like our normal schedule from 5 to 5:30 every Wednesday here on KTLV 1220 a.m. And remember, if you miss these when they're airing live, you can watch them online on youtube.com. That's going to be replays of the simulcast video, which is live during airings on facebook.com on the Sansone Howell Facebook page. Or if you just would like to listen to the audio only, that is available in podcast form on Google Play, Spotify, and the Apple iTunes directory. Friends, this is Jason Sansone. It's been another episode of The Legal Breakdown. Have a wonderful evening. Be safe.